Nelson Dafiamakpo, who has been leading this charge, MP for South Dai, joins me on the line to help us appreciate the position of the minority properly. Hello, Honorable. Welcome to Eyewitness News. This position of yours, the people have been vetted. I mean, the constitutional requirement of prior approval has been done via vetting. And now they are just being moved from one ministry to the other, and you are calling for another round of vetting. Is that what the minority is calling for?
Not at all. There are circumstances leading to this call. We woke up on the 14th of February to news that the president has relieved some 7 ministers of state of their portfolio with immediate effect. The president didn't give them hours to tidy up and depart. He didn't give them a day. He didn't give them a week. He didn't give them a month. He said he was relieving them of their positions with immediate effect. So if you were a minister of state amongst those names that were released, and you were moving to your office in that morning, and you were in traffic, and this news hit you, you were no longer a minister of state. But for which reason you could drive to your office and go and occupy that morning. You were gone. Because midway to your office, the rag has been pulled off under you. Now, within the meaning of Article 81, and if you have your constitution, can we look at it? Hello?
Mm-hmm. Yeah, go ahead.
Yes, Article 81 is to the effect that the office of a member of a minister of state or a deputy minister shall become vacant if A, the appointment is revoked by the president. The letter issued by the president relieving the appointment of the minister listed in that category meant that he has revoked the appointment. And the president added a note of gratitude. He thanked them for their public service and wished them well in their future endeavors. The simplest legal effect of this release is that those ministers, those persons, those category of persons were no longer ministers of state or deputy ministers of state for purposes of attracting courtesies and privileges. Now, the release proceeded to say that some number of ministers who fell within the category of ministers whose portfolio the president had revoked were being reassigned. And with all due respect to the office of the president, that is untenable. Because the law is that ex nihilo nihilo fit. We cannot put something on nothing and expect it to stand. Once you have revoked an appointment of a minister of state, the person is no longer in the position of a minister for which he can be reassigned to another portfolio laterally. But the Constitution mandates the president to re-engage anybody he has disappointed. So if the president is minded to re-engage those persons that he had disappointed some moments ago, he is permitted under Constitution to do so. But they will have to be subjected to the constitutional procedure of appointment. That is nomination, prior parliamentary approval, and subsequent appointment by the president. Because you cannot, by that conduct, sidestep the parliamentary requirement of prior approval in this matter.
I see, but in construing or interpreting documents, what we know is that the document must be read in full. If you read this document in full, the 5-page document, you realize that the issue about the president relieving the 5 ministers of their position, could not have been conclusive, because right in the middle of that document, the president makes the point of reassignment. So is it not just semantics or a matter of I don't even want to call it an error, but in the same document, the needful was done by stating that the 5 ministers in question have been reassigned with immediate effect.
Let me give you an instance. Just last week, there was another release from the office of the president removing some MMDCs from office, 20 of them. In that communication to the whole country and the whole world, a certain law was cited as being the basis of the removal in addition to the constitutional provision in Article 243. They cited a certain law called Local Government Act 2014. My brother, you are a lawyer and a good one at that. There is no such law in this republic. There's no law called Local Government Act of 2014. I have raised the matter. They have refused to correct that error. The applicable law is Local Governance Act 2016, Act 936. That is the appropriate law they ought to have quoted or cited. So you see, these things are not mere mistakes, that they are not mere errors. Communication in constitutionalism cannot be whimsical. Because when you communicate with an effect on the Constitution, it is so heavy that you have to get it right. The president, first of all, revoked appointments of some ministers. And let me ask you, is that document of any legal effect or not? Can you today, for instance, see Ambrose Derry occupying the office of the Interior Minister today in office and not go to Ministry of Interior and occupy the minister's office? He cannot. So nobody can edge it upon me that an aspect of that communication is of effect, but an aspect of it is of no effect. The president was deliberate in revoking the appointment of those number of ministers, and they have all been given effect to. The procedural error here is that he purports to reassign persons whose portfolio he has taken away. And I am saying that the Constitution mandates him to re-engage the people, but he cannot reassign them. He can't use the phrase of reassignment. It has to be reappointment, subject to the parliamentary scrutiny of vetting. That is what he cannot sidestep. And that is the true intention of the president, my brother.
But yes, I'm just wondering what you think the intent of the release or the intent of the president is, because that is also key in interpreting this document. What he intended to do. Did he really intend to revoke the appointment, or he intended to reassign them to other positions?
The man says, I have revoked your appointment with immediate effect. These are not my language. These are the president's language. Then he goes on to say that I am grateful to you for your public service. I wish you all the best in your future endeavors. That is how that communication ended. Which other meaning can anybody place on this communication other than the one I'm urging? So the error rather is to the effect that the persons whom you have removed from office, you now seek to reassign. And I'm saying that by operation of law, by operation of Article 81 of the Constitution, there is no longer a position for a minister whose portfolio has been revoked for him to be reassigned. You can re-engage the minister, but that re-engagement will be subject to the provision and procedure provided under the Constitution, which is nominate, and subject to parliamentary approval and subsequent appointment. It cannot be whisked away. And
I see. Very well. So what do you intend to do? Parliament minority will officially table this before Parliament or the Speaker, and there will be.
The matter today. I raised the matter yesterday. As soon as the release was made public, they sought to say that there was miscommunication of the matter. They haven't made any official pronouncement on it. So I took the trouble to raise it on the floor of Parliament this morning. And I hope that having done so on the floor of Parliament, they will give it some serious thought and put their house in order and do the appropriate thing by remitting to Parliament the names of these 5 ministers of state for purposes of parliamentary vetting and subsequent recommendations for whatever it is worth. If that is not done, I am serving notice. I will proceed to the Supreme Court pursuant to the holding 3 in J.H. Mensah and Attorney General. J.H. Mensah in 1997 said, in constitutional law, there's no place for miscommunication. Because everything that you say that has an effect on the Constitution must be a matter that is heavily considered and communicated. You cannot miscommunicate in respect of the Constitution.
I see.
So I will proceed to the Supreme Court to seek interpretation in the matter, and I'm serving notice that I will injunct the vetting process.
I see.
I will seek an injunction that those 5 persons cannot proceed to be reassigned and act in their portfolios until the final determination of the matter on its merit.
And you are convinced that this will not be a case of a trifle. I mean, the law really does not concern itself with trifles, and you are convinced that this is not a trifle.
Matter. If you were in this country in 1996-97, it was a similar scenario.
No, but the 1996-97 matter, if you're referring to J.H. Mensah versus the Attorney General,
yes,
that was of considerable weight, and that is why today we have what we have now. We have what we call the vetting now, which is the prior approval the Constitution talks about. So that has had a significant.
No. The Constitution has always made provision
for prior approval, but the prior approval was not defined by the Constitution. And the J.H. Mensah case says that Parliament should find or should use its own way of operationalizing what the Constitution is described as prior approval.
Exactly. So I am saying that as for that prior approval, however Parliament operationalizes it, it's up to Parliament. But nobody can use cliché or language to sidestep that process. You cannot remove your ministers from office in one breath and in another breath re-engaging them and say that you are using the phrase reassignment and therefore they will not be subject to parliamentary approval. It will not be.
Very well.
We cannot treat the Constitution or interpretation of the Constitution whimsically.
Thank you so much.
Otherwise, then tomorrow the president can say that my decision to remove certain ministers of state was taken whimsically, and therefore I am reversing that.
Very well. Thank you so much. Yeah, thank you so much, Roxanne Nelson. Interesting legal argument, and we are waiting to see how things pan out, even in Parliament and at the Supreme Court if you have to go there.